Yes, my lord. This is an application filed under Section 5 of the Limitation Act.
First time it has come.
Yes, my lord.
Come for the first time.
Yes, my lord.
Will issue notice here?
No,
my
they
lord,
already received.
We have filed the objection
But
already.
it's not come for the first time.
Not the first time.
First time for hearing.
Without notice, you have filed objection.
This is not the first time, my lord. I have filed my objection.
It's not the first time, madam. This has come up on earlier occasions. He was given time to file objection.
Yes, my lord.
No, not the first time.
What I mean to say is that first time for hearing.
No. Notice yes, you have filed objections. If you are prepared, we can hear you.
Yes, my lord.
How many days delay?
118 days.
Appeal against what?
State government, my lord.
Appeal by the state.
Yes, my lord.
What is the order of the learned single judge?
Yes,
Towards-
my lord. Dated 20.
What is the order? Towards what?
In that said order, my lord, the state government were directed to refund the cess amount of 10%, which was deducted from their award.
Okay, the other matters, similar matters we had.
Yes, my lord.
Okay. Yes, what do you say?
My lord, at the outset, I would like to submit before the Honorable Court that the judgment which is sought to be a challenge was passed as by the learned single bench of this Honorable Court as being covered by one case, one writ petition, which is WPC number 1 of 2024, whereby the same direction for refunding of 15% cess was made. That 15% cess was illegally deducted by the state government in connection with the award of land acquisition proceedings.
Okay.
Then, my lord, in that case, WPC number 1 of 2024, as directed by this Honorable Court, 15% cess has been refunded to the petitioners therein. So, in the present case,
That
there-
WPC 1 of 2024, that judgment was has it been the subject matter of any challenge?
no, they have paid, my lord.
Or they have
refunded.
complied with the order?
They have complied with, I have the documents.
Okay, that is submission made on the merits.
Yes,
On the
yes.
part of the delay, how many days delay, madam?
118 days.
118 days. What do you say on the delay part?
Yes, my lord, they did not explain it sufficiently. The explanation is only casual. I have 3 judgments to rely upon.
Please.
My lord, I have placed 2017 through GLT 487.
2017?
17 through GLT 487. In this case, 99 days delay. An application for condemnation of 99 days delay was rejected because of the,
Mr. Counsel, you have to place before us at least a DB judgment.
my lord,
You have to place before us at least a DB judgment. This is a single bench.
my lord. But
We are not bound by a single bench. You place before us Supreme Court judgment or at least a concurrent bench judgment.
My lord, Supreme Court judgment is there.
Please.
2012 3 SCC 563.
2000?
2012 3 SCC
563.
563.
Yes. Yes.
Para 26, 28, and 29 will be relevant, Your Lordship.
26th?
26, 28, and 29. If I may read, Your Lordship.
Just a minute, please. 26.
And 24 also, my lord. Para 24.
24, yes. Please read.
Para 24, my lord. After referring various earlier decisions, taking very lenient view in condoning the delay, particularly on the part of the government and the government undertakings This court observed as under it needs no restatement at our hands that the object for fixing time limit for litigation is based on public policy, fixing a lifespan for legal remedy for the purpose of general welfare. They are meant to see that the parties do not resort to dilatory tactics but avail their legal remedies promptly. Salmon in his jurisprudence state that the laws come to the assistance of the vigilant and not of the sleepy. Public interest undoubtedly is a paramount consideration in exercising the court's discretion wherever conferred upon it by the relevant statutes. Pursuing stale claims and multiplicity of proceedings in no manner subserves public interest. Prompt and timely payment of compensation to the land loser, facilitating their rehabilitation and resettlement is equally an integral part of public policy. Public interest demands that the state or the beneficiary of acquisition, as the case may be, should not be allowed to indulge in any act to unsettle the settled legal rights accrued in law by resorting to avoidable litigation unless claimants are guilty of deriving benefits to which they are otherwise not entitled in any fraudulent manner. One should not forget the basic fact that what is acquired is not the land, but the livelihood of the land loser. These public interest parameters ought to be kept in mind by the courts while exercising the discretion dealing with the application filed under Section 5 of the Limitation Act. Dragging the land loser to courts of law years after the termination of legal proceedings would not serve any public interest. Settled rights cannot be lightly interfered with by condoning inordinate delay without there being any proper explanation of such delay. On the ground of involvement of public revenue, it serves no public interest. My Lord, at para 26, the Honorable Supreme Court held like this: in spite of affording another opportunity to better file affidavit by placing adequate material, neither the department nor the person in charge has filed any explanation for not applying the certified copy within the prescribed period. My Lord, in the present case, during the period of limitation, the state government did not obtain the certified copy from the registry of the Honorable Court.
When was the certified copy obtained? In this
It
case,
was
our-
obtained on 5/8/2024, where the limitation period has already expired on 24/6,
When judgment is dated?
28/3/2000. My Lord,
23.
Madam, you have your seat. We'll come to you.
26/3/24.
26/3/2000 is the impugned judgment.
Yes, my Lord. The judgment sought to be impugned.
Yes, and
That was passed on 26/3, and the limitation period expired on 24/6.
24/6
2024.
limitation expires.
Yes.
Yes, and when was
Then
the certified copy
the
applied?
certified copy was obtained only on 5/8/2024.
Applied when?
It can be seen at page,
Applied when? Certified copy was applied when?
on the same date, 5/8.
5,
My
8,
Lord, page 16 says,
5 with certified copy applied
applied on 5/8
and obtained on the same date.
on the same date. My Lord, it can be seen from page 16 of the application.
Okay. So you want to contend that even they had not applied for the certified copy within the stipulated period
prescribed
of
time.
limitation,
My Lord.
which indicates that they are negligent.
My Lord,
Okay.
that is how the Honorable Supreme Court has also held.
Okay.
And the next point will be, my Lord, page para 28 and 29 of the Honorable Supreme Court judgment.
Yes,
If I may read, my Lord.
please.
Para 28. Though we are conscious of the fact that in a matter of condonation of delay, when there was no gross negligence or deliberate inaction or lack of bona fides, a liberal concession has to be adopted to advance substantial justice. We are of the view that in the facts and circumstances, the department cannot take advantage of various earlier decisions. The claim on account of impersonal machinery and inherited bureaucratic methodology of making several notes cannot be accepted in view of the modern technologies being used and available. The law of limitation undoubtedly binds everybody, including the government. And para 9, in our view, it is the right time to inform all the government bodies, their agencies and instrumentalities that unless they have reasonable and acceptable explanation for the delay, there was bona fide efforts. There is no need to accept the usual explanation that the file was kept pending for several months, years due to considerable degree of procedural red tape in the process. The government departments are under a special obligation to ensure that they perform their duties with diligence and commitment. Condemnation of delay is an exception and should not be used as an anticipated benefit for the government departments. The law shelters everyone under the same light and should not be swerved for the benefit of a few. In this case, my lord, the application for condonation was rejected by the Honorable Supreme Court.
Okay.
Then my next point, my lord, the applicant has stated in para 7 of the application that there was 37 days So the applicant has, it stated that the applicant has taken 37 days to ponder upon the matter and study the case, and also to apply for certified true copy of the impugned judgment. Although these 37 days has not been mentioned, which dates are these 37 days? There is no mention about the dates and the exact time. Then, my lord, at para 10 of my objection, the applicant shows their own negligence from their statement. My lord, while the additional government advocate general, Mizoram, has already been instructed to file an appeal on 7/2/2024. But the file was handed over to the present council only on 8/8/2024. There is a gap of about 1 month between these two dates. It appears that they did not do any positive steps for filing the appeal. This 1 month was left unexplained in the condemnation application, which shows their sheer negligence, and there is no sufficient explanation for the delay. These are my main points of objection, my lord. And because of the casual nature of explanation, the delay has to be dismissed. And on the merit of the case, the previous writ petition has been, the direction has been complied with. So there can be no ground for appeal because they cannot discriminate the present respondents from those petitioners in the similar writ petition. And I pray your this honorable court to dismiss the instant application.
Yes.
Yes, my lord, regarding
You have a
the...
tough job.
Yes, my lord, regarding to the
Please have your
96...
seat.
Regarding to the 96 days of delay on the part of the state government is that, my lord, one of the state government concern is from Saitwal district. So, my lord, the judgment and order was sent on 28/3, and to receive that judgment and order, the letter have to be sent through register post, and it takes time, my lord. And after receiving on that judgment and order,
After today's internet, days of internet and WhatsApp,
No, my lord, there is a government proceeding that they have to
What has the
examine.
Supreme Court said? That gone are those days when you can cite some technicalities. Now everything is on a button.
And my lord, after examining that judgment and order, and they refer the case to the higher authority, and
Okay,
later
tell us
on-
first why that you have complied with the earlier direction passed in 1 of 24. Is it a
Yes,
fact?
my lord.
It's a fact.
Regarding that, the 37 days delay in the Advocate General Office is
No,
that,
not on that. Learned Counsel has submitted that the earlier writ petition 1 of 2024,
yes, my lord.
whereby there was a issue of 15% deduction of cess,
Yes, my lord.
that has been interfered by the High Court and you have complied with the order.
My lord, I have no
If I
knowledge
may
about
place your
that.
lordship, the documents which I have obtained through
And
the
therefore,
RTI.
he is taking up a plea of discrimination. You don't challenge that order where 15% has been interfered with, and now you are challenging this order where, and that too by a delay of 118 days. What steps have you taken on this matter?
I have no knowledge about that, my lord. We didn't
This
take
is a very
any step.
significant aspect. It cannot be for one case you challenge, other case. If you are challenging, these are policy decisions. You have to challenge for all the cases.
Yes, my lord.
And when was the judgment? 1 of 24? Mr. Counsel?
Yes,
Any idea?
my lord, 18/1, 2024.
18/1/24. No appeal filed till now.
No appeal. They have complied with the direction already.
No,
Because
they
the-
can comply with, they can still file an appeal. But
Without filing any appeal, they comply with the order.
I don't think the government advocate is very aware of the grounds why they have filed your appeal.
No, my lord. This appeal is regarding, the main grounds of this appeal is that there is a challenging of these rules where they deduct the cess amount, and that challenge is upheld by the learned court. So with this ground that we stated that we have a reasonable ground to deduct the cess amount as per the notification.
You don't challenge the rules. Don't challenge it.
It was annexed in my appeal memo, page number 96, my lord. The honorable judgment, High Court judgment is there, where it was upheld the rules.
See, when you challenge the rules, it will have to be before the division bench.
No, my lord, these rules is already challenged
Oh,
and it was upheld. So based on this judgment, we prefer this appeal.
the rules prescribes for deduction of cess.
Yes, my lord.
That rules, validity of rules was the subject matter of a litigation.
Yes, my lord.
That has been upheld.
Yes, my lord.
What do you say on this? Are
I'm
you
not
aware
aware
of
of any challenge made by the state government. My lord, what I would like to,
No, they will not make a challenge. The rules would be challenged by some litigant against the state government. Madam says that it was put to challenge unsuccessfully. Rules were upheld. Which is
Yes.
the judgment?
This judgment is passed by Justice Michael Zoltan Kuma, my lord.
And it's a DB judgment, obviously.
No
it
single
has to
bench,
be
my
a
lord.
DB judgment.
How can the rules, vagaries of a rules be upheld by a single bench? The rules were not, the validity of the rules were perhaps were not the matter of challenge. Rules or notification, what was it?
No, my lord, this is a divisional bench. Yes.
Division bench.
Yes,
Okay,
my
okay.
lord.
Tell us that. Date of the judgment?
No. 28/7/2016.
28/7/2016.
Yes, my lord.
but that cannot, my lord, that is impossible because the revenue rules has been amended only in the year 2023. But the submission made by my learned friend might
Madam, you
be,
need to take instructions.
I think she needs instruction.
We were inclined to dispose of this matter. We have heard him extensively. But it seems you are not having the instructions, proper instructions. Get the instructions. Get the instructions. We are inclined to either take a decision this way or that way. When can you get the instructions? Both on the aspect whether the rules were at all, the amended rules, were the subject matter of challenge and upheld, number one. Number two, very important, maybe you have complied with the direction of 18-1-2024 passed in WPC 1 of 2024. But have you put a challenge to that judgment? You can still comply and still make a challenge. That is admissible, permissible. But have you actually done? If you have not done, can you pick up a particular case for challenge? The delay aspect we'll consider.
Yes, madam.
He has made elaborate submission that as a government, you do not get additional benefit. You will be treated at par. And in today's context, when technology is advanced, you cannot take up the issue that it move from table to table. That's not permissible. Of course, you may not agree with him while he says that every day's delay has to be explained. That is also not there. And that has been done away with. Every day, every moment, no. A delay has to be the explanation has to be substantial, acceptable, and reasonable. That is all. But two aspects, first two aspects. Okay? When can you come back?
Yes, my lord, after vacation.
my lord,
We had given so much of time, we thought it would be okay.
if it can be taken up tomorrow or Friday,
Friday it will not be possible.
tomorrow, my lord, because I do not believe that there was a challenge against the rules.
Your believing will not do.
My
She
lord,
has to take instructions.
in the
You
name of
may be
my lord,
correct in believing, but believe vis-a-vis the factual part. Okay. The instant application has been filed by the state for condonation of delay in preferring a judgment, preferring an appeal against a judgment dated 26/3/2024. Para. Sri so learned counsel for the opposite party writ petitioner has, however, informed that in the objections filed, he had taken up the issue that in an earlier writ petition, WPC 1 of 2024, a judgment was passed on 18/1/2024
my lord,
on a similar issue, which has been complied with.
my lord.
Full stop. He submits that the aforesaid fact would have a relevant bearing as an appeal cannot be filed in a discriminatory manner. Full stop. Para. Ms. So-and-so London State Council submits that she does not have clear instructions or information in this regard and accordingly prays for some time. Para. List immediately after the winter vacation.
My lord.
Obliged.
For hearing, item number 7.
Apologies for interrupting, my lord, but basically, a lordship indulgence in mentioning item number 12. Item number 12. My lord, I am on behalf of my senior Mr. Janiel Tauchong, counsel for the petitioner in this matter, and he has some personal difficulties today. So
12.
12, yes, my lord.
Here and 7. Where are you mentioning now? You should mentioning it at 10:30.
Yes, I was here, my lord, but I was very scared to mention.
You were scared to mention.
Yes, my lord.
Why?
I'm
Now you don't have this care. You have the courage now.
sorry, my lord.
You have real courage to mention at 11 o'clock.
Yes, my lord.
You're lucky.
I will do next
Mentioning
time.
is at 10:30. It's not a question of being scared to mention. Make a mention. If it's a reasonable mentioning, why shouldn't it? Your senior is on leave, we have seen.
Yes, my lord.
You could have gone, okay, we'll grant it as an exceptional case, but don't make a mention when the proceeding starts. Okay? We have been informed that the learned counsel for the appellant is on leave. Para? Other side informed
Yes, my lord.
Yes, I'm for the respondent too.
to the learned counsel for the respondents, including, no, don't say like this. The learned PP as well as the learned counsel for the respondent number 2 are present. Para? Matter appeal is adjourned to be listed after due interpretation.
Much obliged, my lord.
May I please, Your Lordships? In the last court date, we had asked to file an additional affidavit, and we had filed it this morning, my lord, as per section 335 of CRPC.
What is 335, madam?
My lord, delivery of the accused to relatives.
But it has not come.
Sanity taken.
It has not come.
My lord,
Has it come to your?
we had filed in the morning only.
This morning, immediately.
We'll have it after the vacation then, okay?
Yes, my lord.
You are the amicus.
Yes, my lord, I'm the amicus.
Ms. So-and-so Leonard amicus curiae has submitted that an application or affidavit,
Affidavit on affidavit.
an affidavit has been filed under, by invoking the provisions of section
335 of CRPC.
335 of the CRPC. What is the corresponding section? Nowadays you have to put BNSS.
My lord, we did not specifically mention in the additional affidavit.
Of
As
the-
per
of
court's
the
order
CRPC,
dated. Yes.
which is not on record, full stop para. Let the affidavit be tagged with the records and the appeal be listed for consideration immediately after due intervocation.
Obliged.
Item number 8.
My Lord, this is a jail appeal, and I was appointed as the amicus for the appellant. This is regarding NDNPS matter, my Lord.
NDPS.
Yes. If your Lordship is inclined to take up the matter, I will proceed with the facts first.
Yes, we are inclined.
Yes, my Lord.
Madam, you are for the state.
My Lord, before proceeding with the facts, I have two grounds to raise. Number one is with regard to violation of Section 52A of the NDNPS Act. And the second one is conscious possession, absence of conscious possession and absence of mens rea, my Lord. And
What
before,
is 52A?
sorry, my Lord.
What is section 52A?
Thank you.
You said violation of 52A.
Yes,
What is 52A?
52A is, my Lord, regarding,
When does 52A comes into play?
disposal of seized narcotics, drugs, and psychotropic substance act.
So
my
it
Lord.
is a matter pertaining to disposal.
Yes. Disposal
what are-
and regarding the sampling and all, my Lord. Yes.
Before disposal.
Yes.
So it entirely the 52A is on the aspect of disposal. If you dispose the matters, the contraband, what are you required to do? Correct?
Yes, my Lord.
Because this entire section was incorporated because it's only because of having a primary evidence. If
Yes.
you dispose of the matter, the contraband, what will you prove in the court tomorrow? So the samples which have to be done in presence of magistrate, the list of inventory, those will be treated as a primary evidence, notwithstanding anything in the Evidence Act. Please read the last subsection.
Notwithstanding anything contained in the Evidence Act or the Code of Criminal Procedure. Every court trying an offense under this act shall treat the inventory, photograph of narcotic drugs, psychotropic substance, controlled substance or conveyance, and the release of sample drawn under subsection 2 and certified by the magistrate as primary evidence.
As
in the-
primary evidence. Otherwise, in a criminal case, the exhibit, the seized articles are to be proved
Yes.
in the court as primary evidence. Here, to do away with that, this particular amendment has incorporated in spite of the fact that the contraband has been disposed, destroyed, you still have something which can be treated as primary evidence. What is that? The list of inventory,
Yes.
photographs,
Yes.
and the list of samples which are certified by the magistrate, will be treated as primary evidence. What's the violation in your case?
Violation is, my Lord, there was, regarding sample draw, the sample was not drawn at the PO first.
At the place of occurrence,
Yes.
is it required?
Yes, in the standing order, it's written, my Lord.
Standing order of 1 of 2000, which one? New standing order?
1989, my Lord.
1989. One of
Since the incident occurred in 2018, my Lord.
prior to 2022.
Yes, yes.
So this standing order, what does it say?
Yes.
Standing order number 1 of 89. One of 89.
2.2, my Lord.
2.2, yes.
Yes. All the packages containers shall be serially numbered and kept in lots of sampling.
But are you aware that this notification was doubted and interfered with by the Honorable Supreme Court?
Yes, it's in
Which case?
Mangilal, my Lord.
No, the other one. Mohan.
There, my Lord.
Mohanlal. Where is Mohanlal?
Panel is 2016 3SCC.
Yes, 360. Where is that?
Subsection 3 of Section 52 requires that magistrate as soon as
No, you bring Mohanlal. Mohanlal has made a.
I was
there's
not
a-
ready, my lord. Mohanlal, in respect of Mohanlal, I didn't bring the citation, my lord.
Mohanlal has made a specific finding
Yes, my lord.
on this and said that this cannot be operated upon and the legislature is to make a new law.
Yes, my lord.
It's been implicitly it's been overruled. Interfered with.
In that case, my lord, I need to
You
Go through-
You go through Mohanlal.
yes. I need to
City
go
and
through.
there is a very recent judgment, and one judgment, one matter. There are two aspects in NDPS. One is the sampling for the purpose of forensic,
Yes.
and one is the sampling for the purpose of primary evidence. Both are equally important. The sampling for forensic is equally important because you do not know what has been sent to the forensic, whether it is the actual contraband seized or something else. So whether that sampling is also required to be done before a magistrate. There are matters where the testing has to be done at the place of occurrence or somewhere else. There are matters whether seizure has to be done before a magistrate or not. These are all matters which Honorable Supreme Court has laid down many principles. You go through this.
And regarding my lord,
You have got Mangilal.
yes,
And what else?
Mangilal only, my lord, in respect of
There are many judgments.
yes.
Mohanlal, the first, once you have Mohanlal, you will get the later judgments also. You have this thing, pad or something. Can you get that Mohanlal? Will not take up the matter, but we could have indicated to you what we are trying to point out. You have the soft version
Only
of Mohanlal.
mobile, my lord.
Try to.
I'll check it from the SEC, my
With
lord.
my tab. Tab is on the table. You bring it. You can go to this side. No, not. It's on my table. No, we should make this very easy. So that proper deliberation. You have the citation?
Yes, yes, my lord.
16 3 SCC 379.
Yes.
The views of all the states were taken. How do you comply with 52A, including storage space to keep the contraband?
Yes, my lord.
All the states.
Yes, my lord.
Towards the last part.
Most of the states, it start from the
No, 13 starts with the manifest. 13 starts with the line, it is manifest from 15 to 8. Towards the last part, okay, last 3 sentences. Be there is a conflict between the statutory provisions governing the sentence and the standing order issued by the extended government. Is evident that is this standing order, one of which is okay. Either when the two are placed in juxtaposition, there is no case that such a conflict shall have to be resolved in favor of the statute on first responsibility. Well, re-examine the matter and take suitable steps to do it. So this 1 of 89 was done away with by this session. Though it